Good morning, everybody. Welcome to a webinar on Social Enterprise Legal Models Working Group. This is Fiona Martin speaking, and today we'll be launching our Legal Models Work Report and talking to you about some of the issues that we've found throughout that. Now, just a couple of housekeeping things. So I've noticed that can everybody just have a look at their screen and press their hand up or down if they can hear me? Well, if you can't hear me, you won't be able to do this. But if you can hear me, if you could just indicate somehow. Oh, brilliant. So thank you, Belinda, Christian. Hello, Christian. We've met before. Karen, Christina. Okay. So if you have a little familiarization with yourself about the icons and everything in the webinar, so you can clearly hear me, which is great. The easiest thing to do while we're talking is, if you have any questions, and we encourage you to ask questions, is just to type them in the chat box, because we might leave most of them to the end. If there's anything pertinent as we're going through, we'll answer it, but the best approach would be, so it's not a disjointed discussion, is that we leave our discussion questions to the end, but we do really want you to ask questions. The recording, the session is recorded, so you'll be able to listen to it later. And so for your awareness of that, and people who aren't able to attend will be able to listen to the recording. That won't be available for at least 24 hours, though, that recording. Now notice, Francesca, you've got a mic. So just if you wouldn't mind being very careful to make sure you turn that off unless you're actually speaking, unless you need it to hear me. Just so at the moment it's fine, we're not getting any feedback, but just be aware of that issue. So I think that's all the housekeeping I need to talk through. So I'll be talking to you in a minute, but I will leave now and introduce Alan Gregg to you, who'll start the session.
Yeah, thanks, Fiona. Good afternoon, everybody, from wherever you are around Australia. Thanks for joining us. We called the webinar Starting Out in Social Enterprise, What Legal Forms Are Possible. The audience we expected that I've talked to up until now has been fairly much about the basics of incorporating and what might be the best choices to make in terms of incorporation. So we'll get into some of that shortly. But yes, I'm Alan Gregg. I'm the volunteer coordinator of the Social Enterprise Legal Models Working Group, which from here on we will just refer to as the group. And I'm joined by my colleagues from the group, Malcolm Rogers, who chairs the group, and Associate Professor Fiona Martin from the University of New South Wales, and also Declan Cooch from the Law School at the University of New South Wales. Now, I'd like to thank the Business School at the University of New South Wales for hosting this webinar. It's been a good one for us. We've been looking forward to doing it for quite some time. I'd like to thank particularly those who've worked with us in the group over the last few years, and I know some of you are joining us for this webinar. I'd like to also thank the Centre for Social Impact for making available their meeting facilities over the past couple of years as well. Now, for all of you who have joined us, I'm assuming you have an interest in the rapidly evolving environment and innovations in business models and legal structures for social enterprise. However, from the inquiries I have received so far, I'm assuming that what you want to learn today is not so much the high-end discussion about legislative reform for social enterprise, but more the basic choices you face regarding business strategy and what legal structure best suits your strategy. Hopefully this webinar will answer some of your questions and provide you with some of the information you require. So the objectives of the webinar are not only to provide you with an introduction to the work of the group, but also to draw your attention to some of its conclusions on the development of legal models for social enterprise. Over the last 3 years, through a process of research, undertaking a small survey and regular meetings and information sharing, the group has compiled both a report on its work as well as an educational tool that we are calling the Legal Models Comparison Matrix. The matrix highlights how each of the 6 corporate forms legislated for in Australia can work for you as a social enterprise. Special thanks must go here to Mark Ferguson and Katie Mooney of the legal firm Spark Helmore for the effort that they have put in producing this matrix. There'll be much more on this shortly. Basically, the group's report concludes that it is not possible to fully entrench social enterprise characteristics within the legal forms currently available in Australia, and that it needs to work further on investigating legal models specific to the needs of social enterprise. This can be done either through amendments to corporations law or through dedicated legislation such as those being introduced in other countries. Again, more about these later. Now, to assist with this, the group is seeking feedback on the following questions. What might legal forms for social enterprise look like in 5 years' time? Do we need a particular legal form to help grow the social enterprise sector? Do we need particular sources of capital to grow social enterprise? And what support services are needed to foster diverse models of social enterprise? All of these questions have come up regularly during our research. The group's report can be accessed at the link which will be on the last slide, and thanks also to Employee-Ownership Australia for hosting this web page. We've been looking for a spot to put it for quite a few months. The Legal Models Working Group was one of several strategy groups created by the now ceased Social Innovation, Entrepreneurship and Enterprise Alliance, which was an alliance of service providers in the social enterprise field. This alliance produced a manifesto on social enterprise, a copy of which you can find at the link. Pending the establishment of a member-based peak body for social enterprise, which is still on the drawing boards, our work will go on. The group's membership has changed over the 3 years that we've been working, but the core remains involved. The members of the group are listed in the report at the link. The objectives of the group were to identify key issues with choice of legal structures by social enterprise, to analyse, document and propose better use of available legal forms in Australia by social enterprises, to consider and recommend law reforms to enact new legal structures, and to ensure what recommendations we were making are grounded in research. There were 3 separate needs groups that were identified early on as requiring different legal structure outcomes. These were social entrepreneurs, those individual social innovators and startup initiators, group enterprises, the broad stakeholder-owned community businesses, of which there are many around Australia, and the not-for-profits and charities where operating income is generated through trading enterprises, often in hybrid structures comprising not-for-profit and for-profit companies operating as a subsidiary. Early discussions on the work on the group established that most social enterprises face capital-raising questions relating to how they generate the resources and income for economic self-sufficiency, how they raise capital while preserving their social mission in the long term, for example, asset locks, differences in capital needs at different stages of development, for example, start-up and growth. Now, all of these issues impact on the choice of legal form over time. Indeed, legal forms may evolve as you move through various stages. There is much discussion about what social enterprise is. There is no established definition of social enterprise in law in Australia. The landscape is also changing rapidly, with many new business models emerging under the social enterprise banner. A rigid definition of social enterprise anyway might restrict innovation. It might restrict innovation in several ways. On the other hand, it is important to identify the key characteristics that make an enterprise a social enterprise, and the important values that social enterprises stand for. These characteristics make social enterprises clearly different from ordinary businesses, but they also differ from charities and not-for-profits. To assist with considering legal form as the strategic business issue that it is, the group addressed 4 issues of importance to Australian social enterprises. These were how social purpose is reflected in and preserved by the legal form, the treatment of profits or surplus, the ability of the enterprise to raise finance in different forms, particularly equity, the impact of enterprise activity on tax advantages for charities and not-for-profit forms. To assist with addressing these issues, the group has now released its educational tool, the Legal Models Comparison Matrix, which can be accessed at the link at the end. This matrix will assist social enterprises in considering the best form of incorporation to suit their purpose from amongst the 6 forms currently available in Australia. And we'll go through these 6 forms in a minute. So the focus of the group has always been on a particular, the specific form of social enterprise that has commercial activity as its primary motivation. The working group sees the following defining features of social enterprises being important, therefore. They must generate income through trading for social purpose. They must achieve financial sustainability over time, and they must be looking to reinvest profit into the social mission of the enterprise. Social purpose in this context means doing good while not violating important societal values or damaging the environment. It also means having a clear social or environmental objective and vision for achieving it. These absolutely underpin social enterprise. The difference between for-profit and not-for-profit forms are, in my view, not that important, so long as the following 4 key elements are satisfied in the legal form, and this is what we've talked much about in our report. The first of these is mechanisms to ensure that enterprise resources and assets are permanently committed to achieving social objectives, including if the enterprise is wound up. The second one is that some means of third-party validation is necessary to ensure the enterprise's continuing commitment in practice to its social objectives. This might be in the form of governance or through regulation. The third one is a governance structure that provides key stakeholders with the right to participate in decisions about the overall management and direction of the enterprise. And finally, legal certainty about the enterprise's ability to pursue a broader interest in financial return to shareholders or owners. There's some questions of law about that one particularly. Now on these, I'll hand over to our corporate law specialist, Malcolm Rogers, to expand on these matters.
Good morning. One of the questions that the working group asked itself fairly early in its work was, why is legal form important? The first thing that we need to understand is that if you're starting an enterprise of any kind, a business or some other form of enterprise, you have a range of options available to you under the current Australian law. We mentioned a few on this slide here. There's the proprietary company, the company limited by guarantee, a cooperative, and so on. I'll talk a little bit about each of those a little later on. But the key question that we thought was important to address and to communicate in the report is why choosing one form over another is an important decision for people involved in social enterprise. So there are a number of answers to that question. Some of them belong to in any kind of business enterprise. For example, people choose a legal form, among other things, to make sure that they limit their liability in the way that they carry on business, so that the debts of the business become the debts of the business rather than the debts of the individuals who are involved in it. And that those who either share in ownership or in some other way are a member of the enterprise are not themselves personally legally liable for the debts of the business. That's common to all forms of business, and is a consideration that everyone ought to take into account when they're starting a commercial enterprise. Some other reasons that choice of legal form is important are more specific to social enterprise. For example, which legal form you choose as an enterprise might make it easier to preserve the social mission, to preserve the purpose for which the enterprise was established in the first place. It might make which legal form you choose also has an impact on how you're accountable to the people affected by the business, by its stakeholders. A choice of legal form is also important because as a business enterprise, you'll be dealing with people who provide finance, whether they're banks or investors, people who buy shares in the company, and also to the broader community. If your intention as a social enterprise is to say, we're a business and we make our money by conducting a business, but we're different in what we ask you to believe are important ways from other businesses, because we have a social purpose as well as a purpose of making money. So the choice of legal form can be an important way of communicating the difference between your business and your enterprise and other forms of enterprise. One of the things that you'll find, and I hope you all are inspired by this webinar to go and read the report that we prepared in detail, but one of the things that we did as part of the work of the working group was to conduct a survey of some social enterprises in Australia, asking them quite a large number of questions, which are all set out at the back of the report. But particularly asking questions about what legal form the enterprise chose and why they chose it. What were the things that made them choose it? How did the idea for that form of enterprise come about? We issued the survey, I think the slide says 2014, but I think it actually began in 2013 and was completed in 2014. We selected a range of social enterprises who we asked to participate in that, and we had a response number of about 18 responses. That's not a very large number given the number of social enterprises that there are in Australia, and we have to bear in mind that not everybody answered every question in the survey, so that it's not possible to draw any definitive conclusions from the way the survey was conducted, and we have not tried to do that. We have, I think, observed a number of things out of the survey which we think are worth mentioning and are mentioned in the report. The first is that people who start a social enterprise don't seem to pay a lot of attention to legal form at the beginning. Most commonly, they'll go and get advice from someone, an accountant or a lawyer, who will say, oh, it should be that kind of legal form. You should form a proprietary company, or you should form a company limited by guarantee. Our understanding from the survey is that people did not really make the connection between their ambitions as a social enterprise and the choice of legal form. They didn't really explore in a detailed way, as part of the planning process for the business, what legal form might be most suitable for that business as a social enterprise. And they tended to see the choice of which legal form they would use as a technicality, something like how to register with the tax office, let's be a proprietary company, not a strategic issue. And I think our conclusion in the report is that the choice of legal form for a social enterprise that is committed to its social enterprise goals is a strategic issue that should be taken into account and explored thoroughly at the time that people are planning for the business, just as they're planning what goods or services they're going to provide and how they're going to make money. How they're going to do that is an important feature. Let's now just say, and let's just have a look at what options are available. The options that you see on the screen in front of you are explored in a bit more detail, both in the report and in the matrix, which is intended to give people a helping hand to understand what the main differences between the choice of legal form are. All the forms that you see in front of you all the legal forms that you see in front of you on the slide are what are called corporations. That is, they mean creating a legal entity that's separate from the people who are involved in it. There are other structures or forms that a social enterprise might take. For example, it might be a partnership. Many small businesses don't have a formal legal corporation at all. They might be a sole trader, they might be a partnership, and so on. What we focused on in the matrix are the formal legal structures that are available under Australian law for people who want to form a corporation, something separate from themselves. I won't go into a lot of detail here, but let me just run through that list. A proprietary limited company, before I start that, let me say there are a variety of, as well as a variety of forms, there are a variety of regulatory authorities for each of these forms as well. So that what on that slide are called companies are all the responsibility of the Australian Securities and Investments Commission. Incorporated associations and registered cooperatives are under state authorities. The Australian Securities and Investment Commission is a Commonwealth authority. Incorporated associations and registered co-ops are state authorities. Indigenous corporation is a special form of corporation which has its own regulator at the Commonwealth level. Proprietary companies, you'll know, they're what you might know as a private company. And their characteristics are they're usually quite small. You're pretty much free to choose the structure of the company itself. Public companies are companies that are formed for larger purposes. Usually a proprietary company can't have more than 50 people. Public companies are the larger form, so that the companies listed on the Australian Stock Exchange are all public companies. A company limited by guarantee is a special form of company that's traditionally used by not-for-profits. It doesn't have shareholders, so you can't raise money by issuing shares, unlike a public company or a proprietary limited company. An incorporated association, this is one of those state-level authorities, also is a special form of incorporation traditionally used by small community organisations like social clubs or sporting clubs. It too can't raise finance by issuing shares. Registered cooperatives, each state has cooperative legislation. There's now a national form of legislation. But a registered cooperative is basically a member-based organisation, and there are two broad kinds of those organisations. One is where the economic interaction between the member and the cooperative is what drives it. So a dairy farmers cooperative is an example of that. The other form is what's technically called a non-distributing cooperative, and that means that it doesn't have money doesn't circulate between the cooperative and its members, and examples of that might include lots of clubs like bowling clubs, non-distributing registered cooperatives. Fiona reminds me, for those of you who've gone to university and bought books from the University Cooperative Bookshop, that's a traditional member cooperative of a distributing kind, where the money flows around between the cooperative and its members. So we've concentrated here on just making sure that, and the intention of the matrix is to provide people with a very basic understanding of what the corporate forms available to social enterprise are. Let's then just talk about why a corporation might be important. First of all, a corporation and we include in that many of the legal forms that we saw on the previous slide. A corporation promotes a business-like flavour. It gives people the impression that people are taking their business seriously, that they've thought about legal form, and that they've made a choice about legal form that's really part of their overall planning process. It's a separate legal entity, and it provides some limited liability for people who are involved in investors and management. For most corporate forms, there's a separation between the people who are members or shareholders in that form and the main decision-making point of the organisation, the board, so that members or shareholders appoint a board to take the major policy and strategic decisions of the organisation. In larger organisations, the board is responsible, for example, for hiring management, for setting long-term strategy, and so on. It's member-based in the sense that members have the capacity to choose the people who will run the organisation and to hold them accountable. So it's a form of governance and it's a form of accountability. It's also a corporation is also a recognised entity in the marketplace, if you like, so that customers, suppliers, providers of finance like a bank will recognise the corporate form and understand it. And understand what that corporate form means and what dealing with it involves from their point of view. So it's about being professionally serious about the way in which an enterprise is structured and run. I've mentioned before that there are a number of regulators here, and the matrix will help you understand which regulator belongs to which form and what the obligations are in your dealings with the public and the regulator for each of those corporate forms. Now I think we've talked generally about types of corporations and about why you might make a choice about one or the other. I'll now hand over to Fiona, who's going to talk a little bit more about why those things are important for social enterprise and what the considerations social enterprises might need to have in making their choices.
Thank you, Malcolm. So it's Fiona Martin speaking. So is everybody still there? If you want to perhaps give me a smiley face if you're happy with how things are going. I haven't had any questions yet, so you can feel free to type something in if you feel like it. Oh, good. Getting some time. Oh, yes. Thank you, Jemima and Nerida. It's nice to see. So I hope that so far this is helpful information for all of you. Oh, comparison matrix is brilliant. Very good, very clear. Oh, thank you. That's wonderful. Well, I haven't done anything, so hopefully I'll be as clear. So what I'm going to talk about is just some issues that have now arisen. We've had the overview of the different types of legal forms that we've investigated and the analysis of what they do. But let's have a look at how they really impact on running a social enterprise. What are the specific and very, very pertinent issues that are important for a social enterprise, and how can we ensure that our legal structure that we choose is a right fit? And if it's not, well then, what can we do about that? So these are some of the issues here that we've been grappling with over the course of a couple of years now. So how do we ensure that the social mission is maintained? What on earth does this mean? It means different things to different organisations and different people, doesn't it? So it might be something about the environment. We might be making sure that everything we do is very environmentally sustainable and we reduce our carbon footprint. We might be ensuring that we are paying very good wages and that we're trading in an ethical way or investing in ethical ways. So All those sort of things are important when we're talking about a social enterprise, and they may not all be important for the particular social enterprise. It may just be some of them. So how then do we make sure that that's maintained? This is an issue, and really we haven't come up with an actual solution, not in Australia. And you can see from the matrix that there are various, and Malcolm and Alan have talked about the different legal forms that are available, and you can see in the matrix how they're structured, and you have to have some sort of constitution or objective. And we can certainly put in your social mission when you set up or as you progress, and if you change things you can amend that, but how do you maintain it? At the moment there really is no concrete way that you can ensure that this does continue. If the shareholders or the members or whoever you are all decide we're going to sell up and move away from our social mission, or just move away from the social mission without selling up, they can technically do that if they're in one of these structures. Okay, oh yeah, someone's asked where the matrix is, but yes, there's the link. Okay, so that's just an important thing for us all to bear in mind. We're still grappling with that issue, and we'll talk about how it's been dealt with in overseas jurisdictions and how we might move forward in this area in a couple of minutes. An interesting area too that we've looked at is certification, and one of our members introduced us to the B Corp concept, which comes out of the US but is available throughout the world, and that's one form of certification. B Corp is a not-for-profit organisation, and it does offer that certification. And I noticed, Christian, when I was reading your very good article in Pro Bono News late last night, that at the end it said B Corp certified. So it was good to see that. And it's great to see people in the chat room helping each other too. Fantastic. Oh yes, Declan, who's in the room. Thank you, Declan. So that's really good. So yes, we have forms of certification. I mean, we all know about the heart tick on food and all that sort of thing. But our next issue was, well, how accurate is this certification? Well, we don't have a regulator of the social enterprise sector, if you like, as opposed to what we now have as a regulator of the charities sector, the Australian Charities and Not-for-Profits Commission. Then we don't necessarily know whether our certification is accurate or not. We hope it is, and at least it's one step in the right direction. It's definitely showing that the social enterprise we're dealing with, or that we are, has committed to a social enterprise, has committed to being certified, some sort of evaluation. But there's no way of ensuring that that hasn't changed or is really 100% accurate, because we're really in a self-regulatory area. So another issue really, and this is very, very important, and again we've been grappling with this one, and we have ideas about how we can deal with it, but how do we ensure that our assets are always applied to the social purpose? So we might have, for example, a very successful farming cooperative. So it's not a cooperative in the legal sense, but some sort of farming community that operates in a social enterprise way, and it's got very, very assets that are, the land and all the other things about a farm that you might have, and suddenly it becomes very valuable because perhaps it's on the edge of a city, and the city's encroaching on that area, and that land all of a sudden becomes incredibly valuable to property developers. How do we ensure that that land is always kept within the social purpose, the social mission? There really is, unless you take a form which is a legal status really of a charity, then you really have no way of ensuring that in the long term. If your members change, or if they change their ideas or their ideals, or if their circumstances change. So do we want to have that? And we'll see in a few minutes how that's been dealt with overseas. So if that's an issue for you, it would be great to hear from you, and we're certainly trying to think about different ways that we might deal with that. It's sometimes called an asset lock, so you might see that term in the matrix or in other material that you read. Also, another one is, how do our investors get a return on their investment, if that's what we want? Because if we are a not-for-profit in the legal sense, then we don't return profits. It doesn't mean we don't make a profit. Lots of not-for-profits make huge profits, but they don't return that profit to any of their investors or their members or their shareholders or whoever they might be. They can pay them reasonable wages and expenses, but certainly no return on your investment. So, as Malcolm talked about, you know, you've got the PTY Limited company is traditional way of running a business. Again, it's the traditional way, or a public company, of returning to the investors some percentage of the profits in the way of dividends is the usual manner. So at this stage, you know, you have got that issue to think about when you're setting up your social enterprise. If it's important to return to you some percentage of profit to your investors, well then you can't go the not-for-profit route. You certainly can't go the charity route. Okay. Now, we have got an analysis, and this is also on the web page that Alan referred you to. There's a link to quite a comprehensive analysis of overseas jurisdictions, and it's been helpful for us to learn from what these jurisdictions have done and how they've grappled with particularly those two main issues that I raised in the previous slide. And so you can see there on the slide in front of you the three main types of corporate entities that have been developed in three countries that are very similar to Australia. So we've got, in the US, we've got what's called a benefit corporation. Don't confuse that with B Corp. It's very easy to confuse. B Corp is a certification. Benefit corporation is a type of what we would refer to as a proprietary limited company. In the United Kingdom, it took them apparently 7 years to develop this community interest corporation. So you might come across that, a CIC. So that's a commonly referred to type of corporation that's available in the UK. And Canada, some of the provinces there have also developed a community interest corporation type entity. So have a look at the report about this, and also that analysis that we've got. It's a separate document, but also on that same link to that same web page that Malcolm referred you to. I'll just talk a little bit about what they did in the US, because it's possibly a way that we might follow in Australia, because it's possibly an easier way to get through the parliamentary system that we've got. So what's happened in the US, their corporations law is on a state-by-state basis. So they've had to introduce legislative models called benefit corporation legislation in the states, and at the moment it's something like 18 states, it could be more, that have actually adopted this legislation. It's drafted so that the existing corporation code applies to benefit corporations in every respect, except those explicitly stipulated in this model legislation. So this is actually quite clever, because it avoids legal and administrative issues that arise if you have a separate type of corporation. So you've still got the same reporting requirements and governance and all that you would have with a PTY limited company, but you've just got a few differences that ensure that your social enterprise, your benefit to the community, is continued or maintained. So the three things that I just wanted to mention that are really the difference, if you like, between our traditional type of profit company, PTY limited company, and the benefit corporation are that, first of all, we have a corporate purpose that creates a material positive impact on society and the environment. So there's provision for that. There are expanded fiduciary duties, in fact, for our directors of this corporation, which require consideration of non-financial issues. So in other words, whenever they, say, contract with a creditor or they invest or whatever, they don't have to always be looking at, well, what's the best profit? What's the most profit I can make? They also have to look at the social enterprise type issues. So thus ensuring the mission is continued for this entity. And they also have an obligation to report on their overall social and environmental performance as assessed against a third-party standard. So you can see that in this way they have encapsulated this social mission, social enterprise, but they've done it within the existing corporations legislation. The United Kingdom took a very different approach. The Community Interest Corporation is a separate type of entity, has its own separate regulator, and the difference there is that it does have this asset lock, so that you can maintain your assets and your mission. So that's all I really wanted to say about those entities. So we're really getting to the end here, and then we'll have some time for discussion, which would be lovely. So looking at our report, we did recognise after all our discussions and the feedback, and just because we only got 18 respondents to our survey doesn't mean that we haven't had many, many discussions at all sorts of levels with interested organisations. And I think the wonderful turnout of people listening to our webinar is indicative of that interest. So there is a big need out there in the community for some sort of social enterprise structure in Australia, and we recognise that, and we're continuing to work in that area. And we've realised too that our available structures are not always a good fit. I think we've all talked today about these key elements that you can see on the screen. The asset lock that I mentioned, that's that term about making sure we've got some sort of integrity with our assets, that we keep them in working towards our social mission. Our way of distributing profits, how can we do that? How can we limit it? How can we ensure, though, that people do get a share? That's really important. Having that certification, third-party validation, I mean, that is available now, that B Corp, as we've seen. You can get that in Australia. That might be a good way of at least starting out. And if we all start using it, well, then hopefully it becomes a more recognised and valid and credible way to be certified. We need to look at our governance structure. Those various types of structures that Malcolm went through that are available, they do have specific governance structures that may not always be appropriate if we have a social mission. And the legal certainty for directors, are they actually following the law when they follow the social mission, because we don't want our directors to be in breach of their fiduciary duties as a director of a corporation, say, for example. So, I think I've talked quite a bit, we all have. So these are the questions that we've raised. Can we adapt existing legal forms? We've seen how that's happened in the US. Do we push for a new legal form? And we've seen how that's happened in the UK with the Community Interest Corporation. Is it feasible? Yes, as I said, in the UK it took 7 years. There was certainly a lot of will from the government at that stage. Do we have our federal government being sympathetic and with a will to change the situation? So perhaps I'm thinking more an amendment to corporations law might be the way to go, but certainly that's not set in stone. And really, I think that's all I need to say, unless any of my colleagues want to add anything. So it'd be great to have any of you guys type something in. I can ask myself a question, but I'd like to hear from you. Oh, good, Melina. Aha. We'll read this out for everybody. Can an asset lock provision be incorporated into existing co-op legal models so that a new legal structure doesn't have to be created? Oh, that's a really good question, and I'll leave that to Malcolm because he's my expert on cooperatives.
For some, it's nice of Fiona to talk to me as the expert on cooperatives, but I'm not. Let me try and answer that. One of the questions we've been trying to ask ourselves more generally than cooperatives within the working group has been, is there a way that the existing legal forms can be adapted without changing any laws at all? For cooperatives, you have these two classes of cooperatives, the ones that deal with their members, and where the economic relationship is between the cooperative and its members, and then the ones that are more like social enterprise-like, that are designed to produce a community benefit. Now, that latter kind, what the new legislation calls non-distributing cooperatives can have an asset lock, and I think regularly do, saying if for some reason or other a decision is made to stop doing what the cooperative is doing and what's called wind it up, it's not possible for the people who are members at the time then to share in whatever benefit there is from the sale of assets. That has to go to another cooperative that has the same kind of limitation on it. Now, that said, so you've got a legal form that does permit that, but there are also limitations for a social enterprise in having one of those cooperatives. For example, it might be very difficult to raise finance from a traditional source, like a bank. You can't really raise money. There is a mechanism in the cooperation legislation that allows you to offer things, a form of share that's a bit like the share of company issues called the cooperative capital unit. But in practice, it's not used very much at all. So the financing problems have to be offset. You might have your asset lock on the one side, but you may have just created financing problems for yourself on the other side that make it difficult to actually get the cooperative to work as a commercial enterprise.
I think that's great. Now, anybody can't add anything? Oh, Alan, did you want to?
Just adding to that. I mean,
Alan's going to add something.
Some of the better-known social enterprises in the UK, like Greenwich Leisure, which is a cooperative, have set up a subsidiary CIC company in which I think they've placed their assets. That is to ensure that the assets are locked in a way, and I mean, cooperatives can still have the members, I think, vote to demutualise, as we know. The only way of ensuring, I think, that the assets remain in perpetuity for the social objective is that I can see in law is through the community company structure or corporation form.
Great, thank you for that. I notice Tim Hand has asked for information on the Indigenous corporation, so I can answer that a little bit. So we've covered them slightly in our matrix. I'll just go to the last slide where you've got the links to the report and to the matrix so you can see. So Indigenous corporations are dealt with under what we call the CATSI Act. So that's the Commonwealth Aboriginal and Torres Strait Islander Act. So it's Commonwealth legislation. The regulator there is the Office of the Registrar of Indigenous Corporations, ORIC, O-R-I-C. So you can go onto ORIC and you can search and find out just about anything you want to know about an Indigenous corporation that is covered by that CATSI Act. Usually, the ones that I've come across in my research are incorporated under the Native Title Act. There's a requirement that you actually incorporate under the Native Title Act. And the corporation there, it's this Aboriginal corporation, and it has members. It doesn't have shareholders because the Native Title Group is the traditional owner group, which is an amorphous group of owners, really. It's just continually changing as people pass away or people are born. And the reason we have a corporation, though, is what Malcolm mentioned, is that we need to have this separate legal entity that the market can deal with, that the market can contract with, that banks can. You know, it's hard for it to raise money, but if they can, the banks can contract with, but certainly that they can deal with creditor issues, and they can buy things or sell things or whatever it might be. So you need to have that corporate entity to deal with. So it's a separate legal personality. But again, when we have a traditional landowner group, then we have members, as I said, and we don't have any distribution of profits. So again, it's limited that way. It's not really great for carrying on any sort of enterprise. And my experience has been that the native title groups or the Aboriginal land rights groups will set up a separate Pty limited company, possibly even a charity, to do community development type activity. Oh, so I hope that answers your question, Tim. Oh, there's some more questions. Oh, this is good. Many thanks. Well, oh, good. Okay. That's brilliant. So Christian, hi. In the case of corporations, is there a requirement to maximise returns to shareholders limited to financial returns?
And there's also 2 questions above.
Oh, okay, thank you. Oh yes, thank you. Could a constitution potentially define returns as financial plus social, include an asset lock and limits on dividends, etc., like a CIC? Well, I think Malcolm wants to answer this.
Yeah, well, let me start, perhaps. Done that first part of the question.
Right. Okay, so we'll go back to you. Okay. Can you read that?
Unlike the American laws, the Australian law generally, the Australian law that applies to companies, to proprietary limited companies or to public companies, does allow the board, as the governing body of the organisation, to take into account things other than just return to shareholders. I think it's probably settled law in Australia that if you do something that's not strictly about financial return to the company, but about a donation to a charity or a political grouping or something, that's provided it's in the best interest of the company as a whole, and that's fairly expansively interpreted, so that a lot of things can be done. There is a problem, I think, and the problem that you'll see if you read the report, the asset lock is a slightly different question, because what might be difficult under the existing legal forms in Australia, and here talk about the companies under the Commonwealth legislation, it might be difficult to create what we've been calling an asset lock. That's basically something that prevents whoever are the members or governing body of the company at a point in time from saying, well, we're not really interested in producing social benefits anymore. We're a successful business. Now we want the profits from that business to come to us as the owners of the corporation. It might be difficult under current Australian law to create a watertight mechanism that says at no stage and under no circumstances can the members or the shareholders of the company make a decision like that. We've kept things reasonably simple today, but within the working group we've also talked about other more complex legal structures that might help achieve that end. The one example that we won't go into today because it is complicated is the use of trusts. And some social enterprises in Australia do use trusts to create that kind of asset lock mechanism. But it is complicated. You need considerable legal expertise, which usually means expensive legal expertise, to produce that result. So I hope that is the beginnings to answer the question. I think Alan wanted to add.
There's another question.
Yeah, we've got a
Tatiana?
from Tatiana here from Social Enterprise in Sydney. My question is, B Corp certification is pretty expensive considering the startup costs social enterprises face already. On top of that, they have to pay company registration. I feel that having a social enterprise structure with some tax benefits, etc., would encourage more people to start social enterprises. Do you feel that would be the case? Well, I think that's the conclusion the Legal Models Working Group is coming to, that it is probably something that we need to get onto the legislative table as a separate legal form for social enterprise, but that may take some time. In the meantime, we're trying to replicate or set up some kind of template process where we can develop a constitution that as much as possible gets the provisions that you're looking for into something you can design yourself within a company structure. It wouldn't be watertight, but it's probably better than the loose kind of arrangements that we have available at the moment. So we're trying to design that as well. But there may well be somebody, we've heard recently that there's been a top corporate lawyer who's actually designed something within existing corporations law that will serve the purposes of an asset lock, but we're yet to see that and whether it actually works. But possibly we could have an Australian version of the community at this company like they've developed in Canada. Yeah.
I just wanted to say, it's Fiona here, I just wanted to say as well, that's an interesting question, Tatiana. Something that I should have mentioned, none of these overseas examples that we talked about, the Benefit Corporation or the CIC, they don't have any tax breaks. So they are taxed in the same way as any other business, which is interesting. They didn't manage to ever negotiate that. I also think, yes, you're right about the B Corp certification, and it is an added cost, and why should you have to do that in a way when you're already, it's really just confirming what you're already doing. So I think that's an important issue.
Just on the tax break situation, in the UK now there is a tax break for social investors who are investing in equity in social enterprises. So that means that the company limited by guarantee is not eligible for an investor, whereas a community-less company is the most eligible form for that tax break. But that's for the investor, it's not for the company itself.
There's another question. So there's now a question from Susan. Have you researched risks and outcomes for social enterprises which set up a hybrid structure? Yes, well, I think that's what we've been talking about. Well, we could talk about that a little bit more. Yeah,
I just want to make the point there that, yeah, the hybrid structures can be fairly complex. They can get messy. They can get really messy if the structure you've set up for the social enterprise, if that actually fails, it will have an impact on the NFP. It might well bring the NFP down with it if it does fail. So you always have to watch those kind of arrangements. But there's certainly plenty of them around. Hybrid structures are quite a headache for the not-for-profit sector. I think it will become more so, I guess, as the tax regime comes under investigation.
Okay, so we've got a couple more questions, which is brilliant. Thank you so much. Wait a minute, I'll just go back. Sometimes hard to keep. Any views on the efficacy outcomes of B Corps? That's from Melina. Have there been deregistrations? That's a really good point. I might leave that to my colleagues because I don't know of any deregistrations. I just know that it's available and it's certainly being used. It seems to be quite popular, but that's about all I know about it.
It's a form of certification. It's not actually a legal structure itself, but we do know of one case in Australia that was very strongly promoted as a B corporation, which has since sold or it's been merged with another company and has ceased to be a B corporation. So I don't, you can't always guarantee the ongoing objectives of the B Corp will be served through annual certification.
I'm just wondering, well, this is a sort of a question for everybody, but does B Corp take note of what's going on and then issue sort of a withdrawal of its certification? I'm not sure if it does.
I think
Alan might be able to help. Malcolm.
I think there's a requirement in, or the way that the B Corp certification process works is that you do need to be recertified each year.
Yes.
But there are no consequences from ceasing to be a B Corp.
No.
It's, as Fiona says, it's not a legal structure. It was intended to be a branding mechanism so that businesses who wanted to be seen as creating some kind of doing business in a socially responsible way or for social outcomes would be able to have themselves certified by a third-party entity that said yes, and it's a complex mechanism of certifying and testing whether the corporation is actually achieving those. They might be the way that they treat their employees or the way they interact with the community. And there is a certification process which has been picked up by quite a large number of companies around the world. But it is really a branding exercise for some form for companies who want to identify with community benefit. And it's commercial. While it's run by a not-for-profit, I mean, it's a commercial enterprise in that sense, so that they charge money. And it doesn't answer some of the questions that we've been posing in the report about how do you make sure that a social enterprise sticks to its social enterprise character over time. There's nothing to stop you saying, today, yeah, we're a B Corp last year, but we don't want to do that stuff anymore, so we won't bother with renewing our B Corp certification.
Yeah, the certification process for B Corp is quite rigorous. I mean, I think it's quite of value to organisations to do it.
Oh, okay. This one, Adele. So Adele, I'll answer your question. We're probably getting to the end of our time. I'm not sure how much longer we all have. But yes, I'll answer this one. It may be that we can't answer everybody's questions, so I do apologise in advance for that. But Alan has very kindly given his contact details, so he may well.
Not a lawyer.
He's not a lawyer. Some of us are, but we don't practice as lawyers, so we don't give legal advice. But we're happy to have conversations. We love discussing this area. But Adele, yes, you're asking a very interesting question there, which I have a little bit of expertise on. A structure of social enterprise as an incorporation gaining DGR status. I'll deal with that first. DGR status is this for everybody is when an entity, it has to be a not-for-profit. Well, it will be, and it's an entity that if you give donations to it, so gifts, they have to be no strings attached type gifts. So donations are tax deductible. So DGR is the term for a deductible gift recipient. There are nearly 50 ways of becoming a DGR. The most common is to be what's called a public benevolent institution, so an organisation that provides relief to people in necessitous circumstances. It's a very, very difficult status to get. There are particular categories, like, as I said, like PBIs, public benevolent institutions. Certainly some types of environmental organisations can get it. But unless you come within one of the categories or you're specifically listed in the legislation, then you can't get that. So it's not something that a social enterprise can easily get at all. And that's in the existing legislation. And then what have you said as well, Adele? Sorry, I haven't read the whole question. Oh, I see. So you set up a separate DGR that you make donations to.
Would they be tax deductible in the hands of the...
Well, if you're giving to a DGR, it is tax deductible. That's fine. I mean, you don't have to even set up a separate one. If you find a DGR that's got the same ethos and mission as your own social enterprise, there's no problem with that, and that's tax deductible. It just depends, I suppose, on the structure that you have for your social enterprise, whether making those sort of donations is part of it. And a lot of companies do this. I mean, you come across big companies like AMP or National Australia Bank or whatever, and they might not call it a donation, they might call it sponsorship, but they sponsor very worthwhile enterprises that will often be deductible gift recipients. And even if they're not, if you're an incorporated entity, so you're say for example a PTY limited company, then you can spend money in sponsorships, and that's if it's part of your carrying on your enterprise, then it's just deductible under Section 8-1 as a cost of carrying on your business. So that's another way you can do that. But all these things, this gets into the very complicated area of tax and charities and not-for-profits, which we know is very important, but we haven't got to grappling with a report about that as yet. So
there's also a question about
30% tax relief. This one, Christian?
Yeah,
that's a good question.
There was one. She was saying that there is 30% tax relief for investments in community interest companies in the UK.
Oh, Christian, yes.
Someone's asked. Yeah.
Oh, yes.
Someone's asked before that.
Okay.
In the case of corporations, is the requirement to maximise returns to shareholders limited to financial returns? And could a constitution potentially define returns as financial plus social, include an asset lock and limited dividends like a
Whose question is that?
We partly answered I was hoping we'd partly answered this question before.
Let me tell them what question we're talking about. Which question was it?
That one's Christian's just
Christians. We're just about to answer Christian's question about constitution.
Yeah, I hope we've partially answered it before. It's up to in the ordinary company forms. It's really up to the founders of the company to decide what's in their constitution, and there's nothing in the law that prevents them saying, this is a company that's going to, we hope, make a profit, but it's also going to carry on certain activities or do socially beneficial activities. There's nothing in the company law that says you can't do that. The company law is a very open structure, so provided it's not illegal, you could have in your constitution a commitment to doing really pretty much anything you like. Where the problem and where the asset lock question comes in is how do you hardwire that in so it can't be changed down the track? And that's the question we've been looking at in the working group. And the answer is that looks like it's fairly difficult under most current legislation. That's not to say it's impossible. And one of the things that we've been trying to look at is if you did try to do that under, say, existing company law, what would it look like? Now, we haven't found a clear answer to that question. And it may be something we've got to talk in the working group about exploring whether we'll take that question further, because there are basically two ways of doing it, as one of the slides says. Either you adapt an existing form without changing the law, or you ask the government to change the law. At the moment, if it was possible to really hardwire that in so it couldn't be changed at any stage in the future, that's the question we're asking ourselves, because the company structures are based on the idea that it's the members of the company who get to make the ultimate decisions. So if they decide to create an asset lock or something that looks like an asset lock in the first place, they might change their mind down the track and change it back again so that it behaves. And what can you do to prevent that? That's where we started to get into the more complex areas, like saying, well, is there a form of trust or some other mechanism, a golden share, some sort of mechanism that you could hardwire that in. We're not concluded on that question yet.
There's also the related issue about directors' liabilities. And you say you're carrying on a social enterprise and it's in the form of a company, so a PTY Limited or a public company, then you have to make sure that the directors aren't in any sort of breach of their fiduciary obligations. And one of the fiduciary obligations, one of the, I suppose, missions, if you like, of a corporate structure is to maximise profit for the benefit of its shareholders. So we don't want our directors clearly to be in breach of that. So that's another issue which really hasn't been tested by the courts that we can see in Australia. Covered everything? Yeah. So I think we've covered everything. And as I said before, you can see at the last slide, you've got all the links to all the relevant sites and all the documents. I did notice one question about a recording. Yes, this webinar has been recorded. The recording won't be available for at least 24 hours, and we will have to set up a link where you can access that. So we'll be working on how we do that to make it publicly available, because this has been provided by the University of New South Wales, this webinar, and usually with this sort of system is available for students. But we will be in contact about that.
And by contact, the easiest way, if you want a copy of it, send an email to Alan Gregg at the address, at the web address that's on that last slide there, and Alan will, when it becomes available, Alan will be able to send you a link.
Okay, everybody.
No, that's fine.
Thank you, everyone.
Answered questions, or
There is just one on whether there's been any research on risks and outcomes for social enterprise which are hybrid structure. So anything more than
We sort of covered that,
you've sort of spoken to that.
So thank you everybody for your attendance. It's now 1:10, and it's been hopefully a helpful session to you. I've certainly enjoyed it and enjoyed being a part of this working group. And now if I could just ask everybody to sign out of the forum, that would be really terrific. Thank you.
Thank you. Goodbye.
Goodbye.
Goodbye. That's right.